question number 1. So the question number 1 is, which of the following is not considered? Kindly pay attention to these kind of negative words whenever you are reading the question, and read the question very, very carefully. So it is written that it is not considered a violation of right to equality. And right to equality is mentioned under which article of our Indian Constitution? It is mentioned under Article 14 of our Indian Constitution. So your statement number 1 is conferring of Padma Awards. Your statement number 2 is reservations to the SCs and STs in public employment. Your statement number 3 is privileged treatment to a local upper caste man and the same is denied to a scheduled tribe man. So select the correct answer using the codes given below. Your option A is 1 and 2 only. Your option B is 3 only. Your option C is 1, 2 and 3, and your option D is 2 and 3 only. So your correct answer is going to be option A. Statement number 1 and 2 only are correct. So, Article 18 of our Indian Constitution talks about the abolition of titles, and this right provides that the state shall confer no title on a person except those who excel themselves in military or academic fields. It is not considered to be a violation of your right to equality under Article 14 of our Indian Constitution. So if you'll study about Article 18 in depth, you will notice that it prohibits only hereditary titles of nobility and the constitutional validity of the national awards, namely Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri, has been upheld by the Honorable Supreme Court of India in a 1998 judgment, and that is why your option number 1 is correct. If you talk about option number 2, that is reservations to SC and ST community in public employment. So yes, they have this right to reservation in public employment by virtue of Article 16 Clause 4 of our Indian Constitution. So, Article 16 Clause 4 of our Indian Constitution states that the state may make any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. This is required for the fulfillment of right to equality of opportunity, and this is also known as the affirmative action of the state. And hence, statement number 2 is also correct. And if you talk about the statement number 3, so Article 15 of our Indian Constitution specifically prohibits discrimination on certain grounds. So, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, equal access to shops, hotels, wells, tanks, bathing ghats, roads, etc. Okay. Hence, the police officer giving a privileged treatment to a local upper caste man from a rich family and the same is denied to an scheduled tribe man is violation of Article 15, and that is why your statement number 3 is not correct. Moving forward to the next question of our today's discussion. So the question is, which of the following statements regarding preventive detention laws have been in focus throughout the year of 2023, especially the PMLA, UAPA. So all of these laws have been in focus. Okay, so which of the following statements regarding preventive detention are correct? Your statement number 1 is, Parliament has the exclusive authority to enact a law of preventive detention for reasons connected with defense, foreign affairs and security. Your statement number 2 is, the state legislatures have exclusive authority to make a law of preventive detention for reasons connected with the security of a state and the maintenance of public order. So select the correct answer using the codes given below. Your option A is 1 only, your option B is 2 only, your option C is both 1 and 2, and option D is neither 1 nor 2. So your correct answer is going to be option A, 1 only. So if you talk about the Indian Constitution, Article 22 of our Indian Constitution, Article 22 of our Indian Constitution grants the protection to persons who are arrested or detained. And preventive detention means detention of a person without trial and conviction by a court. It is only a precautionary measure to prevent him from committing any offence in the near future. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. So if you talk about this statement number 1, it is absolutely correct, because Parliament does have a exclusive authority to enact a law of preventive detention for reasons connected with defense, foreign affairs and security. But if you talk about the statement number 2, not only the state legislatures but the Parliament as well. So both the state legislatures and the Parliament have exclusive authority to make laws of preventive detention. That means their power is concurrent in nature, and that is why your statement number 2 is incorrect. Moving forward to the next question of our today's discussion. So the question is, which of the following statements with respect to writs is or not correct? Again, a negative word. Okay, whenever there is a negative word, kindly read the question very carefully. So your statement number 1 is writs are borrowed from the American Constitution. Your statement number 2 is the writ jurisdiction of the Supreme Court is wider than that of the High Court. Your statement number 3 is both the Supreme Court and the High Court cannot refuse to exercise its writ jurisdiction. So select the correct answer using the quotes given below. Your option A is 1 and 2 only. Your option B is 2 and 3 only. Your option C is 3 only, and your option D is 1, 2 and 3. Okay, so all of these statements are incorrect in nature. Writs are not borrowed from the American Constitution. Rather, they are borrowed from the English Constitution. And in the English law, they are known as prerogative writs, and hence statement number 1 is not correct. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas the High Court under Article 226 of our Indian Constitution can issue a writ for the enforcement of fundamental right as well as a legal right. And hence statement number 2 is not correct. The writ jurisdiction of the Supreme Court is not wider than that of the High Court. Okay. If you talk about the statement number 3, a remedy under Article 32 in itself is a fundamental right, and hence the Supreme Court may not refuse to exercise its writ jurisdiction. Okay. Even the High Court is not empowered to refuse to exercise the writ jurisdiction, and hence all of these statements are incorrect in nature. Moving forward to the another question of our today's discussion. So the question number 4 is, which of the following Constitutional Amendment Act added a new directive principle related to the cooperative societies? Your option A is 42nd Constitutional Amendment. Your option B is 44th Constitutional Amendment. Your option C is 86th Constitutional Amendment. And your option D is 97th Constitutional Amendment. Okay, so your correct answer is going to be 97th Constitutional Amendment. And it added a new DPSP related to the cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. Article 43 Clause B of our Indian Constitution contains provisions regarding the promotion of cooperative societies. So your correct answer is option D, 97th Constitutional Amendment Act. Moving forward to the next question. So the question number 5 is, consider the following pairs. Your pair number 1 is Uniform Civil Code, Article 43. Your pair number 2 is Definition of a State, Article 36. Your pair number 3 is Participation of Workers in the Management of Industries, Article 43, Clause B. So, which of the pairs given above are not correctly matched? Your option A is 1 only, option B is 1 and 3 only, option C is 2 and 3 only, and option D is 1, 2 and 3. So, a correct answer is going to be option B, 1 and 3 only are not correctly matched. If you talk about the Uniform Civil Code, it is mentioned under Article 44 of our Indian Constitution. Okay. Article 36 contains the definition of state, and not Article 43 Clause B, but Article 43 Clause A is related to the participation of workers in the management of industries, and that is why your option number B is correct. Moving forward to the next question. So the question number 6 is, consider the following statements. Your statement number 1 is novel features. Your statement number 2 is instrument of instructions. Your statement number 3 is conscience of the Constitution, and your option number 4 is heart and soul of the Indian Constitution. Which of these statements given above does not accurately describe the directive principles of state policy? Your option A is 2 and 4 only. Your option B is 3 and 4 only. Your option C is 4 only, and option D is 1, 2, 3 and 4. So your correct answer is going to be option C, 4 only, heart and soul of the Indian Constitution. So Dr. B.R. Ambedkar described directive principles of state policy as novel features of the Indian Constitution. Okay, DPSPs have close resemblance with the instrument of instructions mentioned under the Government of India Act of 1935. That is why statement number 2 is also correct. And Granville Austin has described DPSPs as the conscience of our Indian Constitution. Your statement number 3 is also correct. Okay. And if you talk about the statement number 4, that is heart and soul of the Indian Constitution, it is Article 32 of our Indian Constitution. that provides a right to constitutional remedy. You can enforce your fundamental rights under Article 32 of our Indian Constitution. And Dr. B.R. Ambedkar has described the right to constitutional remedies as the heart and soul of our Indian Constitution. So that is why your option C is correct, 4 only. Moving forward to the next question. So your question is, which of the following statements is not correct about the fundamental duties? Your option A is, they help the courts in examining and determining the constitutional validity of a law. Your statement B is, they serve as a warning against the anti-national and anti-social activities. Your statement number C is, they are extended to foreigners as well. And your option number D is, Parliament is free to enforce them by suitable legislation. So your correct answer is option C. It is not correct, okay, about the fundamental duties. So fundamental duties help the courts in examining and determining the constitutional validity of a law is correct. In 1992, the Honorable Supreme Court of India ruled that if a courts find that the law in question seeks to give effect to a fundamental duty, it may consider such law to be reasonable in relation to Article 14 of our Indian Constitution or Article 19 of our Indian Constitution, and thus the Supreme Court is empowered to save such law from being declared as unconstitutional in nature. Fundamental duties serve as a warning against the anti-national and anti-social activities like burning the national flag, destroying public property, and so on. Unlike some of the fundamental rights which extend to all persons, whether citizens or foreigners, the fundamental duties are confined to citizens only. They are not extendable to foreigners. Because why will a foreigner have a fundamental duty towards Indian Constitution? So this is the logic behind it, and that is why they are not extended to foreigners. The Parliament of India is definitely free to enforce them by suitable legislation, and hence your option C is the correct answer for this question. Moving forward to the next question of our today's discussion. So the question is, which of the following statements are correct? Your statement number 1 is, Article 15 of the Constitution of India is available to both citizens of India and the foreigners. Your statement number 2 is, Article 16 of the Indian Constitution is available to the citizens of India only. Your option number 3 is, Article 21 of the Constitution of India is available to both citizens of India and the foreigners. So select the correct answer using the code given below. Your option A is 1 only, option B is 2 and 3 only, option C is 3 only, and option D is 1, 2 and 3. So your correct answer is going to be option B, 2 and 3 only. Okay. So elimination method is applied. Okay, you can apply the elimination method and you can judge that yes, Article 15 might not be available to the foreigners. So fundamental rights available to the citizens only are Article 15, Article 16, Article 19, Article 29 of the Indian Constitution, and Article 30 of our Indian Constitution. So these fundamental rights are available only and only for the citizens of India. Fundamental rights that are available to both citizens and foreigners are Article 14, Article 20, Article 21, Article 21A, Article 23, Article 24, 25, 26, 27 and 28. So these are the bunch of articles that are available to both the Indian citizens as well as the foreigner nationals. So that is why your correct answer is option B, 2 and 3 only. Moving forward to the next question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, forming a cooperative society is a fundamental right in India. Your statement number 2 is, 42nd Constitutional Amendment Act 1976 gave a constitutional status and protection to cooperative societies. Which of these statements given above are correct? Your option are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. So your correct answer is going to be option A, 1 only. Forming a cooperative society is a fundamental right in India by virtue of the 97th Constitutional Amendment Act of 2011. A cooperative is an autonomous association of persons united voluntarily to meet their common economic, social and cultural needs and aspirations through a jointly owned and democratically controlled enterprise. The 97th Constitutional Amendment, as I said, gave a constitutional status and protection to the cooperative societies. It made the right to form cooperative society as a fundamental right under Article 19 of our Indian Constitution. Cooperative society plays a vital role in ensuring the nation's progress by helping the poor, illiterate and unskilled people to form a union with the principle of mutual assistance to achieve their common socio-economic goal. And that is why your correct answer is option A, statement number 1 only. Moving forward to the next question of our today's discussion. So the question is, consider the following statement. Your statement number 1 is Article 31B protects the acts and regulations included in the 9th schedule of our Indian Constitution from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Your statement number 2 is Article 31 Clause C provides that no law that seeks to implement socialistic directive principles specified in Articles 39 Clause B and Clause C shall be declared void on the grounds of contravention of the fundamental rights conferred by Article 14 and Article 19 of our Indian Constitution. So, which of the statements given above is our correct? Your option A is 1 only. Option B is 2 only. Option C is both 1 and 2 and option D is neither 1 nor 2. So, correct answer is going to be option C. Both 1 and 2 statements are correct. So, you remember when we enacted the first Constitutional Amendment Act, we wanted to abolish the zamindari system. We wanted that the land should be equally distributed. Okay, we wanted to the land to come under the purview of the government of India, and that is why we had the first Constitutional Amendment Act, and we also wanted to establish a welfare state. So, the first Constitutional Amendment Act 1951 inserted Articles 31A and Article 31B to the Constitution of India. Article 31C was inserted in the Constitution of India by the 25th Constitutional Amendment Act. If you talk about Article 31 Clause B, it protects the acts and regulations included in the 9th schedule from being challenged and invalidated on the ground of contravention of any of the following fundamental rights. Because if you remember that right to property was a fundamental right at that point of time when we had the first Constitutional Amendment Act. Right to property was removed as a fundamental right only after the enactment of 44th Constitutional Amendment of India. Okay. The scope of Article 31B is wider than Article 31A as it immunizes any law included in the 9th schedule from the fundamental rights, unlike Article 31A that protects only 5 categories. However, the Honorable Supreme Court of India in a very landmark case that is also known as the 9th schedule case, and the case name is I.R. Coelho. Okay, I.R. Coelho case ruled that even laws under the 9th schedule would be open to scrutiny if they violated the fundamental rights or the basic structure of our Indian Constitution. At that point of time, the basic structure of the Indian Constitution was already evolved in the Keshwanand Bharti case, and that is why both of these statements are correct. Now, let us discuss a practice question of our today's session. So, the question is, consider the following statements with reference to the veto power of the President. So, statement number 1 is the President can exercise veto powers with regard to the constitutional amendment bills. Your statement number 2 is the President cannot exercise veto powers over the state legislations. So, which of these statements given above are not correct in nature? Your option A is 1 only, option B is 2 only, option C is both 1 and 2, and your option D is neither 1 nor 2. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. Until we meet next, keep practicing, because practice is the only solution to avoid any kind of negative marking. And whenever you are practicing the PYQs in the subject of polity, please pay attention to the options as well, because what the UPSC does, it makes question on the options next year. Okay, so this is the pattern. We have already done a trend analysis on this. So till the time we meet next, keep practicing. Thank you.